Hi teammates, this is Krista Nepper, founder of Work Like a Girl, and you are watching Work Like a Girl Wednesday. So today we're going to continue our discussion with regards to sexual harassment, and we're going to specifically talk about the topic of retaliation. So before we get started with that, I just want to do a quick recap as to last week's video and the 101 on sexual harassment. Last week we discussed what sexual harassment is and isn't, and we talked specifically about the fact that the Supreme Court has identified two types of sexual harassment. One being quid pro quo, which I like to call the vanilla flavored, hey, if you sleep with me, you'll get the raise type of sexual harassment. And the second being hostile work environment. That is when working conditions are so hostile that you're unable to adequately do your job. Now, in order to have a sexual harassment claim, 3 items must be met. First and foremost, the behavior must be established as unwelcome. The behavior must be severe and pervasive. And third, if not for the fact that you were female based on your sex, the harassment would not have occurred. So once that's established and once you are able to file a complaint, then your employer may not retaliate against you. So this applies whether or not you file an internal complaint with Human Resources, whether you file with the government agency. The EEOC, or Equal Employment Opportunity Commission, is available to take complaints, or you can file a private lawsuit. And there are a lot of great HR professionals out there, but this is also one of the areas that I've seen employers get it really wrong, because it applies not only to individuals who file a complaint, but to individuals who express an interest in filing a complaint, to individuals who express support for their colleagues for filing a complaint. It applies to employees who refuse to testify on behalf of their employer or who do testify against their employer and help a colleague or support a colleague in that manner. So Title VII is very broadly written, and know that you are protected no matter what. So when we say the word retaliation, what exactly do we mean? If you read Susan Fowler's blog post, she mentioned a couple of different things that happened to her, and those items are both illegal under Title VII. First and foremost, she talked about favorable reviews being changed to unfavorable reviews. This is pretty common practice when there is someone attempting to sabotage a victim of sexual harassment. So that's first and foremost illegal. She also mentioned how she asked to be moved from her division to a division that felt more friendly, and her employer refused to do so. That is also illegal. So favorable reviews becoming unfavorable, moving or refusing to move someone, notes suddenly put into your employment file complaining about how your performance is inadequate, being demoted, having a decrease in pay. Any of that is retaliatory and illegal. And also, if you take time off, whether it's with short-term disability, if what you've experienced has been so traumatic and you qualify under that, or whether it's family and medical leave or vacation of any type, you are allowed to come back to your same or a comparable position. And if you are not allowed to do so, that is also retaliatory. Now, I certainly know that what the law is and what happens in actual practice are two very different things. So if you have specific questions, I invite you to ask them in the comments below, or if it's something that's confidential because of your current state of employment, I invite you to come over to the Work Like a Girl Facebook page, and you can also private message me there. Remember, knowledge is power. So if you have questions about any of this material, please let us know, and please share it with your friends. Until next time, I'm Krista Nepper, and this is Work Like a Girl.